Ken Gordon is with us this morning. Ken retired from Baker & McKenzie LLP as the chair and founding member of the global and North American pharmaceutical and healthcare industry groups in 2009. Ken currently serves on various boards and has 20 years of experience serving on healthcare, corporate, civic, and professional boards. He currently serves as chairman of the board of the directors of Community Hospital Corporation. His undergraduate degree is from Tufts University, and he holds a JD and an MBA from Northwestern University. Ken Gordon.
Thank you. Good morning. Oh, all right. So I need your help this morning, so let's try that little piece again. Good morning.
Good morning.
Thank you. How many of you love your lawyer? All right, got a little applause, a few hands. How many of you wish you had a different lawyer? Okay, that's what we're going to talk about today. And so what we did in order to try to figure out how to, what to talk about and what the issues are is we actually ran a survey of people in your positions. So across the FARB membership was our driving force. For those of you that don't know FARB, it's an association of associations of professional boards across several different disciplines, not just healthcare, but we had probably mostly from healthcare in response to our survey results. We surveyed board members, we surveyed board executives, and we surveyed their lawyers. We did run the lawyer survey separate from the board survey, and we'll give you a little bit of taste of both of those. But the driving force behind this, the idea was that in the hallways of meetings like this, we heard a lot of complaints about the lawyers. Gee, my lawyer's not letting me do this. I think it's a great idea, but we just can't. My AG says it's not possible. Those kinds of answers, and so we got to getting to the point of, okay, what do we do about this, and how do we make this work? So we ran the survey, and I want your help in guessing what this is. Now, I've got a little precocious hearing loss, so I'm going to need you to shout out some answers to my questions here. So the first question that we asked was, our board, the board executive and the attorney work well together. For the board members and the board executives, what percentage do you think said strongly agree or agree to the answer here? Just shout it out. Less than 50%. 20%. 30%. Okay, hold that for thought for a moment. What percentage of the attorneys said everybody's working well together? 75, 10. I like this. This is good. And the survey says 92 to 94%. Only less than, well, let's round it off to 1% of the lawyers disagreed. And just so you know, when we're going through this, because I got 5 or 6 more of these, the 0 of the lawyers ever strongly disagreed with any answer. Okay? Just so you know where we're going with this. So the next question. Our board is effective at carrying out its role in public protection. Board members and board executives, what percentage? 50%, 65%, 80%, 98%. Okay, hold that. The lawyers, what percentage of the lawyers? 90%. I heard a number over here. Anybody besides? Okay, so the survey says 86 and 90%. You're getting the idea here. This is where we're going. The next question. Our board is able to respond to current issues in a timely manner. The board members and board executives. What percentage? Let me hear you. 85%. 90%. All right. Of the lawyers? About the same. A little lower on this one, but pretty comparable to each other. So we're still over the 80% threshold. You get to statistical significance, or you get to the 80-20 rule of life, we're still over 80-20 here. Current policies and guidelines support consistent, equitable enforcement. The board, folks, what percentage? Sorry? 75. 60. All right, the attorneys, what percentage? You folks are losing your energy here. 90%. All right, folks, there's a trend here. You're all in the medical profession. Think this through. What's the trend that's going on here? The next question. Our board, staff, attorneys have appropriate instructions, resources, and they are held accountable. Isn't that great? The board side, what did they say? What percentage said strongly agree or agree? 90. We're catching on here. And the lawyers, what percentage of them? Okay, well, I cheated a little bit. This one was a little bit lower. But you're getting the idea here. Our attorney is always prepared. What percentage? 90. And the lawyers? Oh, come on. The lawyers are saying that they're always prepared. It was 97% of them. What else were they going to say? Our attorney effectively facilitates pre-meeting discussions and allows the board to make its own decisions. This is the complaint that caused us to do this presentation and to do the survey. What were the results? What did the board members say to this one? 85, 90. All right. The lawyers, we didn't even ask this question of the lawyers. There seemed to be no reason. Our board is effective at communicating expectations and providing feedback to the board attorney. Feedback. How much of that happens, right? What's the percentage from the board? 90. And the lawyers? 90, 85. Okay. 90 and 85. All right, you're catching on here. The board administrator, attorney roles and responsibilities are clearly delineated. You believe that, don't you? Isn't that how your board is set up? What percentage? 90. Well, not quite. All right. So what did you learn from that? They're all lying. We had 400 people respond to this. We were pretty happy with the response across lots of boards, as I said, and attorneys, attorney generals, private practice, the gamut. I think it was 25 or 30 different boards received this survey, 400 responses, actually meaningful from my academic colleagues telling me this. And 90, 85, I mean the lowest percentage was 80. What did we learn from that? And it starts with really technical legal terminology here, diddly squat. I don't know about you, but if everybody's agreeing, what are these complaints about? Really, what are we hearing? Why are these complaints just anecdotal? What's going on with this? Well, the good news was, in addition to asking questions like that, just do you agree or disagree, we also asked for a lot of commentary, and we got an amazing number of responses. Now, I do have to tell you up front, the overwhelming commentary matched the statistical results. So it was things like, yeah, my lawyer's great, or we get along really wonderful, or she knows everything under the sun and I never have to worry about anything, or my board administrator is really communicates with me really well. Comments like those. But of course, if I shared those comments with you, you'd be bored by the end of the hour and have learned nothing. So I was a little picky in terms of the responses I got from over hundreds of pages of comments where they were all squished together. So I'm telling you, there was a lot of information. And I boiled them down to a few different areas, and we're going to talk about those areas of emphasis, because I do want to leave you in a position today to work better with your lawyer. And I don't care whether that lawyer is an assistant attorney general, which is the way I'm going to describe them. I know there are lots of different descriptions in different states, deputy attorney, whatever. But a government lawyer. There are also private practice lawyers. Your board situation is going to vary from the person sitting next to you. As you know, we've got autonomous boards, semi-autonomous boards, we've got consolidated boards, we have independent boards, and your authority and ability to hire lawyers is distinct and separate from each other in those regards. None of that really matters. I spent my career in private practice, mostly with large law firms, all of it dedicated to the healthcare industry. But the rules about how I could be effective with my clients and how my clients could be effective in managing me were very much the same as they are whether you're talking about practices like those or in government relationships. So the takeaways are across the board, even if you have to tweak them a little bit to your own situation. I also do want this to be dynamic. We can't obviously spend all day answering questions, but if something pops up, please feel free to bring it up. I want to keep that energy in the room that we just got started with. 90, right? Okay, so the first part of the discussion, and the first element really relates back to training that I got back when I was a fifth-year lawyer. So about 5 years out of law school, my large law firm decided that all of us lawyers should get trained in marketing. When I started going into law, I had that age-old thought about what lawyering was and what the profession was like, and that image of the 1920s and Atticus Finch and all that. And I didn't have to market. I didn't have to go out and meet people because clients came to us. That's that's the nature of the profession, and it was one of the high professions. And people came to us and they needed help, and there was really no doubt about that. Well, by the time I started my career, that had begun to change, and so my law firm decided we should have a marketing consultant, and they should come educate us, all of us lawyers. And I was lucky enough that they included the associates back in the days before I became a partner. And the one takeaway from that, all these years later, that I still remember was, we're in the relationship business. Now, the question that this slide asks you is, what kind of relationship do you have with your lawyer? And what kind of relationship do you really want? And how can you get there is going to be the point for this discussion. Because it really is all about the relationship. If you take nothing away from my presentation this morning, take away, it's all about the relationship. Now, there will be a second point which will go to communication, but really, what is communication? It ties back to the relationship. So those are closely linked. So I'm including commentary from the survey. Most of my comments are going to, most of my slides are from the lawyer side because I thought those would be more interesting to you. When I gave this presentation at the FARB regulatory conference several months ago, most of the slides that I used there were comments from the board members so that the attorneys could learn. But the truth is, there's a ton of commonality between the two. Really is. The people are having the same kinds of insights, but coming at it from different points of view. So does your lawyer try to sway your advice? We hear this all the time. My lawyer tells us what we have to do. My lawyer doesn't really have an opinion of her own. She just does whatever her bosses tell her to do. Well, there's a piece of that that's true, probably, particularly for the assistant attorney generals or deputies that you work with, because most of them are younger. They're closer to being out of law school. Let's think about your budget on your board, whether it's a separate board or even a combined board. Do that as a percentage of the overall state budget. And when you have that many zeros immediately after the decimal point to the right, you're not getting the most expensive, most experienced lawyer in your government. You're also probably not getting the most expensive and most experienced lawyer in the law firm that you've hired, if you've gone that direction. Now that's just facts, that's not a problem, and you know who your lawyer is and whether they fit that description or not, but it is often the case that that lawyer has to go back to someone senior. Now that's not all bad. I spent many years of my career trying to teach and bring along and train junior lawyers that were coming along in their career, and I gave them as much client time and face time as I could because they were going to grow as a lawyer better, they were going to do a better job, and truthfully, they were going to love their work more. All good employee motivator kinds of things. At the same time, they had to come back to me and say, well, Ken, how do we handle this? What do we do here? And the truth is, as a client, you would want them to do that because you don't want the answer of a second-year lawyer. What you want is the answer of the 20-year lawyer. But the 20-year lawyer is back at the office. So some of this is not bad. But you do want your lawyer to think. And you want them to understand, and you want them to be able to work with you the way that you want them to work with you. So we're going to have to talk about this one a little bit more and figure out solutions to it as the morning goes along here. The board finds itself in an adversarial relationship. They don't treat us as a client because they're really worried about getting elected again. Well, there's some truth to that. the Attorney General is the only one that gets elected from that department, right? But the Attorney General also gets to appoint and select many of his senior lawyers. Now, some of that's civil service and some of that's really separate from the politics, but not all of it. By the time it gets to the lower level lawyers, those people really are not politically involved in terms of their own job security, but they do have a political point of view often, and they are supportive of the attorney that has been elected. Not always, but some of this can happen, and I'm sorry I don't have any solutions for you on here. It's just fact of life. Now, we will talk about how to work with this, how to manage it so that it doesn't become the problem, because the politics in the state are not what's driving. Particularly for you board executives in the room, and when I saw the hands up, most of you have some years of experience in that role. You know you're dealing with the individuals, and what goes on with the politics is often at a higher level. Most of your issues are not political issues. We spent the last hour talking about some that are, but most of your issues really don't boil down to politics. They boil down to getting the job done and doing it well. So how do we make that happen? We asked the question, well, what if your advice is not followed? And I love this answer. Maybe this was your lawyer, I don't know. Well, I must have spoken in French because they didn't do what I told them to do. The tongue-in-cheek was really, really good. Now, I included this part of it because we got some responses and some commentary like this of, they didn't do what I told them to do? Of course they do what I tell them to do. And on the board side, I was able to get through, 5 or 6 pages of the commentary report because the answer was, yes, we do what the lawyer tells us to do. Yes, we do what the lawyer tells us to do. No, we don't have a problem. It just keeps working out fine. It goes along. It's good. So that was the overwhelming response, as you saw from the initial survey results. But it's kind of a little ego in this one. Well, this lawyer actually did tongue-in-cheek with this answer. I included it because it was fun. And the rest of her response was this slide, which is far more powerful and far more valuable. If we've outlined the law and the board makes a particular decision, that's cool. That's the board's decision. If I've explained the rationale and they understand the consequences of their decision, that's cool. Now, why is that an important thing for you to remember? Why would I really want to emphasize this? The answer is because it's your decision. You're the board. The attorney is never the board. It is never the attorney's decision. Okay, there are a couple of instances where that's an exception, which is why you never use the words never or always in life, right? But for the most part, like 99% of the time, it's not up to the lawyer, even though the lawyer might make you feel like it is, or the lawyer might act like it is. It's a decision for the board to make in your best judgment about what that is. This slide captures it. The lawyers get it. It's really interesting reading their commentary. And I don't say this just because I was a member of the bar till I retired. They do get it. These are the kinds of answers we got often. They do understand that it's not their decision. They do understand that they are there as advisors to you. They are consultants to you. They might be the most articulate in the room on why they think a particular answer is the way it should be. They might feel the most strongly about it because they're focused on the law. And that's a good thing. That's what you want them to be focused on, but it's not always the only piece of the pie. The equation can be far more complicated than that, and they are just well-informed, well-educated opinions, hopefully. Or, as you'll see, maybe they're uninformed because they weren't prepared. I don't know. You'll have to figure that one out in any given situation. And then another problem that we get in that arm wrestling side of the relationship that I showed you that picture earlier is we get lots of changes. The Attorney General's office is always changing who's assigned to us, and so it's difficult to develop some consistency across the board because their opinions differ. Well, interestingly, if you remember that earlier slide where I was talking about the young lawyer going to the senior lawyer and getting advice on how we should handle a particular situation, well, that's a good thing, I said, because then you're getting that senior lawyer's advice. Now, it's a bad thing because it's not always quite to your specific situation, and again, so there's two sides to that sword, and this has the same problem. The consistency is a problem changes because you really want to deal with somebody over time. Doesn't have to be 10 or 15 years, but at least 2 or 3 or 4 or 5 would be helpful to get that consistency, those relationships established so that you can have a great working relationship and a successful board outcome. Now, there's not a lot you can do with that, but if the young lawyers are the ones being moved around and they're talking to the more senior lawyers, you do tend to have more consistency even in the Attorney General's office at those more senior levels, unless there's been a rout on the political side. But that consistency up there can lead to some more consistency of answers. So one strategy you might have would be to actually ask your younger lawyer to go talk to one of the senior lawyers and see if you can get a more consistent kind of advice. That's kind of concrete, but that's just one strategy you might employ. So most of what I've talked about so far on the relationship side has been that arm wrestling. How do we get beyond that? How do we get to this kind of relationship? This is what we're after. Professional, teamwork. There are multiple people here. We don't actually know who they are. It's just a slide off the web, but maybe it's multiple board members all working together. It's a couple of attorneys, a couple of board members. Who knows? But it's coming together. How do we get there? And the first word I'm going to put on the screen is going to sound obvious, but bear with me for a few minutes. Listen. That's a two-sided conversation. Get your lawyer to listen to you, and I will share some thoughts on how to do that. And I'm going to ask you or challenge you, are you really listening? The challenge with lawyers, and this is a lawyer thing, lots of them can't speak past the law. What I mean by that is they can only speak in lawyer speak. The law says this, or let me quote this long statute. And that's the answer to your question. As a lawyer, that used to drive me nuts because I knew that when I was a client, and now I am a client, I see the other side and I'm like, I read the statute. I know what it said. I want to know what it means. I want to know how to deal with this. Tell me, lawyer, what this... So the lawyer speak is not helpful, but what does listening require? You've all been to classes, you heard about it in school, you've dealt with it. Active listening. Active listening includes not just using your ears, but it includes engaging your brain. I challenged you earlier. See the trend, find it, and identify it, and you did a great job. The other part of it is asking questions. You'll hear this from me several times today. Ask the questions of your lawyer. Now, be careful. You'll hear this from me a couple times too. Be careful with questions. There are two kinds of questions in this context. There's the question that's really a challenge. I'm asking you this question because you're wrong and you're not letting me do this thing, and I'm telling you that, but I'm putting a question mark at the end of my sentence so it doesn't sound as bad, but listen to my voice. I'm challenging you. That's really not a helpful, active listening kind of a question. But the question that demands from the lawyer to get underneath and get to why. What's really going on? What's the opinion? Why? What is that opinion based on? And not just a recitation of the statute, but what piece of it that I can hang my hat on to understand you, lawyer, about what you're saying to me. If you push them. We lawyers love to just answer the question. We're right. We know we're right. I promise you, you work in the healthcare industry, right? So you work with your orthopedic physician. At the risk of stereotyping, athletic trainers, physical therapists, family practitioners, orthopedic surgeons, neurosurgeons, the stereotypic orthopedic surgeon, he knows he's right. And he's going to tell you he's right, whether he uses those words or not. Look, I'm getting nods around the room. Yeah, you know those orthopedic surgeons, all right? Folks, the lawyers are the same way. Government lawyers a little bit less than private practice lawyers. Small firm private practice lawyers a little bit less than big firm private practice lawyers. So caveat, I worked in big firms most of my career. So I'm telling you right now, I know I'm right about this. Lawyers think they're right. And they'll make that known by their presence, by the words they use, by the tone that they use, and merely their stature. And when you're dealing with assistant attorney generals, many of them actually do find their way into the courtroom from time to time, or have. And when you're in the courtroom, folks, if you're not like super, super confident and presenting that image, you've lost before you even started. The jury is not going to find for you. The judge is going to think you're a Nimrod. So that's what that lawyer training is all about. That's what it does to us. Or maybe it's how we were and that's why we became lawyers, but that's the topic for another day. I may be going too slowly here. So in addition to the active listening, it's critical that everybody understand their responsibilities and their roles. And if you think about your boards, and of course, everybody's situation is different, so I can't quite get at your individual circumstance here, so you got to think about it. Does everybody really understand what they're responsible for? If there's a disciplinary action going on, do the attorneys know what their role is? Do you know what the attorney's role is? Do you know what the board executive's responsibility is versus what the board member's doing? If the board members are simply rubber stamping what the board executive says or what the attorney says, then I submit to you that the board members are not fulfilling their responsibility. You heard in the introduction, I'm chairman of the board of a hospital company. We own half a dozen hospitals. We manage another dozen. We provide consulting services as well. And so just different kind of an example here. We get the financials presented to us. We're not going to get into all the details of the financials. We're a board. But I challenge my board and I say, if you don't ask questions about the financials, you're not fulfilling your responsibilities as a board. We have to challenge the staff in order to make sure that they know and to make sure that these numbers are right. When you're sitting as a regulatory board, you have the same kind of challenge. Whether it's a disciplinary matter or it's a routine licensure matter or whatever it is that comes through, how were the processes? Were they being followed? What's unique about this particular individual? What's unique about this circumstance? You need to actually ask some questions to do your job. And if you're just rubber stamping, that's not working. Now, most boards don't, so don't misunderstand me. I'm not being critical of the way boards work. I'm simply trying to give some examples about how dynamic this has to be and where those roles and responsibilities and how critical it is that everybody understand those. If everybody understands what they're responsible for, they can make that happen. The attorney can make happen her job, and you can get from the attorney what you need from them without feeling like they're overstepping their bounds. But if they see that the board's not doing its job or the administrator's not doing his job, then that lawyer's going to step into the gap, on purpose or by accident. But somebody's going to step into that gap, and that's where you get this feeling that I hear so much in the hallway of, my lawyer's running the show. My lawyer tells us what we have to do. Okay, are you interrupting? Are you asking? Just some questions, and I'm trying to state those. I felt like I was a little bit challenging of you, and it's not my intention to challenge you in those regards as much to say, think about how you can get more from your lawyer, and the technique is ask more questions, fulfill your role, and ask that the lawyer fulfill her role only to that extent of what that is. So in addition to relationship, I mentioned that communication is critical. It boils down to effective communication, understanding. I could have put understanding in place of education, but education is how we get to those understandings. And it's an education in both directions. The attorney should educate you about a whole lot of stuff. Think about what it was like when you first joined your board. You were like deer in headlights, right? What is all this stuff? So the lawyer can help educate you. What's the law? What are the rules? How does this work? What's the legal process for the disciplinary activity? How do these hearings work? All those kinds of things and a bunch more. At the same time, you can educate the lawyer about what's going on in the profession. She's busy. She's representing 18 of boards like yours, just to pick a number, but it's not far off for many of them. And they're quite distracted by doing all that work, and they're going from meeting to meeting to meeting, hopefully doing a little research on the side, hopefully getting you well-reasoned answers to your questions, but they don't really know what's going on in athletic training. So let them know. Benefits to that we'll talk about a little bit, but that's where I'm going with this next topic. So there's confusion about the tasks, who's responsible for what. I kind of delved on that a moment ago. The process is confusing. Who's in charge here? And it's a legitimate question. And all of your boards and all of your states are going to answer that question in a variety of different ways. Not 53 or 57 different ways, but maybe a half a dozen different ways or more. What's the process? Do you understand going in what that process is going to be? And if you're the typical board member, you don't until you've been through it a few times. But typically, your lawyer has been through it multiple times, unless you've got a newbie, So we get to educate the lawyer about how this goes. But typically, the lawyer's been through it lots. Why? She represents 18 different boards. If it hasn't happened at your board in 5 years, it happened to another board just last week. And so that education, that upfront, how do we get things done, what's the process, are great questions, and without it, it leaves everybody confused. A lot of overlap. Goes back to the question of what's the executive responsible for, what are the board responsible for, what's the attorney responsible for, who knows what that is, and the result in the room, the vast majority of the time, I'll stick with that 80 or 90% that we got from the survey earlier, the vast majority of the time, if there's chaos in the room, what the lawyer says will control. Why? Well, I talked about the lawyer's point of view, or who the lawyer was earlier, and I'll add another element to that now. Because most of our population in the United States, well, actually most of the population in the world, defers to the lawyer. I don't know. Is it because they went to school for 3 more years? Probably that's not enough of an answer. But they sound like they know what they're talking about. They've thought about it, or at least they sound like they've thought about it. And so, okay. And I trust her. She's a lawyer. So, sounds good to me. But then that's not very fulfilling, is it? So, and it's not our serving the purpose of the board, which of course is public protection. Now, the attorney might be all about serving the public protection. Hopefully he is, as he's giving advice. And where does it go for the rest of the process? Where really is that fitting in? Whose judgment is applying here? That's what you were appointed for. So we got to try to get through those. Now, we talked earlier, or at least I showed you a slide about feedback. The lawyer doesn't know that you're not satisfied. The lawyer doesn't know that you're confused unless you do something. You give feedback. Now, that feedback can be in the form of, hey, I don't understand, or can you explain, or questions like that. Or it can be in the feedback in the form of, we really need this from you and not so much of that. This is the kind of information that we need. Now, this often falls to the board executives to do, or the board chair perhaps, if that relationship or person is stronger in dealing with lawyers. But giving that kind of feedback, especially lawyers who have practiced for less than 10 years, and even more obviously less than 5, they really need that feedback about how to communicate. You know that $5 million vocabulary you've got that, caused you to get an 800 on the SAT? I need you to not use that vocabulary. I do a ton of volunteer work now that I'm retired. And one of the first things I had to learn was how to move my vocabulary from postgraduate to high school, junior high. And that's not an insult to the people that I work with on a volunteer basis. It is about communicating. And if I use words in that 8th grade, 9th grade level, maybe 6th grade level, I'm going to communicate much more effectively, much faster than I am if I'm using super big words that they got to figure out what it is I'm talking about. Same thing goes for the lawyers. And I just use vocabulary as an example, but it's probably bigger in the long sentences, those memos where the sentence is that long, right? I know how to write those sentences. I still like it when I do. but then I go back and add periods and take my semicolons out. So give feedback to your lawyers, find a way to do that, and understand most lawyers, like doctors, were educated to act individually. They either, again, were that way and became lawyers as a result, or they got educated through law school to act that way, but they tend to think individually, they tend to work individually, so they're not always so receptive to feedback. So you got to be careful about how you do that. Be insightful. This is a place where you and your profession in particular, you're in a people profession, right? You got to communicate with your athletes in a particular kind of a way, in a compassionate, in an empathetic, in an understanding kind of a way, in a way that they get it. Okay? Lawyers are no different, folks. You have to find a way to communicate to them so that they will provide for you what you want. We'll talk a little bit about how to do that too. There were also a number of responses to the survey that said something like this. As the in-house lawyer to the board, I'm involved in everything. And I actually like that. My personal opinion is that's what we're looking for. Why? Because that lawyer is attending conferences like this, or maybe at the professional side, where they're getting to know what's going on with the profession. They know you as board members. They know you individually and collectively as board members. They understand how that works, who you are, what the dynamic is. They're involved in everything so that they can also present to you what you need. So I did not read this one as domineering, but more as this is how you get effective. As an outside lawyer in private practice, I was much more effective for the clients that got me engaged in their businesses, whether it was a hospital or a doctor's office or it was a medical device company, that if I knew the insides about how their organization was working, then I was going to be much more effective instead of that client that just called for the one-off, how do I do this, or what's this about, or is this legal kind of a question. If I got a one-off, it was much harder. Now, being an industry specialist, I was able to abstract a lot and bring more to the table, but that's not always true from your attorney general because, once again, as I said before, she's busy across a lot of boards. So if you can integrate your lawyer into your board's activities, that would be a stronger result. I also like this one. This was forward thinking, and I believe the future of great success and a challenge to many more boards. I think this is an exception. Maybe 5, maybe 10 states have people who are doing this, and then again, only in some boards with some lawyers. I don't think this is the norm. But to the extent you can get your lawyer to do some board education, that will be great. Why? The board's going to be smarter, better informed. Those roles and responsibilities are going to be performed better, and understanding the law, how it works, or the legal process, how that works, or whatever it is, the more knowledge we have as board members is going to make us better. And I've already talked about the flip side, where the more educating you can do of your lawyer, the better that lawyer is going to be able to serve you. Education programs where you have the lawyer come to you and present can also be flipped around if you can get them to stay that extra 30 minutes or hour, so the discussion that follows they become part of and they witness. They'll learn from that as opposed to actually having a formal session or education program. It can also happen over lunch if you can pull that off. So we also asked the question of a few people, what would enhance the functioning of the board council? How would they be better? And we got another helpful answer: time and opportunity to learn the issues percolating in the profession. I've already hit this a few times, but at least one lawyer recognized that would be helpful. There are programs like FARB's Regulatory Conference. I don't know if you have some or if the profession does. But again, getting the lawyer to understand what's going on behind the scenes is really, really helpful. The third major theme I want to hit, I've talked about relationships, communication, and education. And the third one is think strategically. It really means think ahead. So we don't normally think about calling our lawyer and bringing them and getting them involved in this and working out ahead. What we tend to do, and this is the world at large, I have a legal question I need to ask a lawyer. And that's true whether you're dealing with your estate plan for your family, or you're dealing with as a board member, or in your practice as an athletic trainer, or if you're in the school, dealing with the school board, which you may or may not deal with. But it's typical, people will just say, oh, that's a legal question, I have to get a lawyer involved. But if you can anticipate where this is going to come from, issues that are starting to arise, it may be easiest in the investigations area. It also happens in the regulatory framework. The nurses were talking about scope of practice issues. It happens with scope of practice. Hey, this scope of practice question is starting to percolate out there. Just want you to know, nothing for you to do now. 3 months later, you remember that scope of practice question that I told you about 3 months ago? Well, it's coming along and this is where it stands now. Now we need to begin to prepare. We need to begin to think ahead. Lawyer, can you help me think about strategically how to do that? Really helpful on the lobbying side, but also helpful on the drafting of regulations, and even helpful on the investigations and some of the more routine things. Again, the tighter the teamwork, the tighter the relationship you can build with your lawyer, the better your lawyer is going to be for you. As I said, the lawyers are extremely busy. It's crazy at the Attorney General's office. I had not only the good fortune of representing some clients in front of boards, I also got to work with the Attorney General in Texas on drafting some legislation and on writing an informative book on HIPAA when it first came out on what it meant, because nobody understood it, including the lawyers. So we wrote a book that was only about half as long as the 1,000,000 pages in the HIPAA, trying to explain each individual line and how to deal with that stuff on the privacy side, so that I got to see the Assistant Attorney Generals on the inside, how busy they are. They really, really are busy. They are pulled in 1,000,000 different directions. They're not well paid for it, and they're not necessarily well prepared for that level of craziness. So how do you cut through that? Because that's what you got to do. The answer is give advance warning, get in line. If you need an answer tomorrow, that happens, and that's okay. They'll respond to that. But if you can give them a month's notice, a few weeks' notice, whatever that is, your situation's going to be better. Because then when you call and say, hey, my meeting really is tomorrow, I haven't heard from you, they're like, oh, right, you were in line and I need to get that back to you. Those are not the words that get used, but it is the concept. So the more advanced communication you can have, the better. I've already mentioned this, really keep them informed of developments, both with the board and what's going on specifically with specific matters coming to you, board executives, particular issues that are crossing your desk, particular concerns that you have, keep your lawyer involved. Make your lawyer a team member with you, but also those professional matters is probably where it gets to be. Practice prevention. What I mean by that is not the practice of athletic training. What I mean by that is think in advance. Prevent the problem. Same theme, communication. Thinking ahead. Where's this going to go? This particular matter, that lawyer representing that AT who's coming before our board has a real reputation of being a complete, well, you can fill in the word. So, lawyer, I need you to be prepared for that. You need to know that's coming, and I need your help, because we got to protect the board from this, and so it's much better if it's lawyer to lawyer and manage that. Well, if you know that's coming and you can do that, that's all the better. Same is true on the lobbying side, right? Follow up with your lawyer. I gave an example just a moment ago. You gave the lawyer a month's notice. They did what lawyers are best at. I promise you. I don't know. We don't get trained this in law school, but my mother told me it's true of every lawyer that she ever knew, and she'd married one and had a son that was one. And it's absolutely true. We are great procrastinators. We're really, really good at it. Now, my son, who's about to enter college, might have me beat, but I'm hoping well, anyway. But because we procrastinate so well, so you give a month notice. You've taken my advice and you've gone off, you're trying to work ahead, you've given a month's notice. Hey, I need this month, and it's a day from now that you need it. Well, don't wait a day. Maybe you want to follow up. Give that advance notice. You'd like to send out your board packets about a week before your board meeting, hopefully. Back that up a week. So you gave a month's notice, but really it's 2 weeks. Follow up at that point. How you coming? Any questions I can help you with? Do you need any more information? Don't get on the phone and say, where's my memo? Okay, that's not relationship building. But how can I help you, busy lawyer? I know you're busy. How can I help you serve me? Bottom line, in all aspects of work, and those of you that work in schools see this even more, You don't only manage down, you also manage up. Now, we can argue whether a lawyer's up or over or all that kind of stuff, and I don't really have an opinion, and it doesn't matter, but you got to manage that direction just as much or more than you think you might be being managed by the attorney. Use those techniques and keep to the tight deadlines. Agree in advance what those deadlines are. Hey, I'm going to need this in a month. Can you give it to me in 3 weeks so that I can review it, you and I can talk about it, and then we can get it out? Great. And then hold accountability. You don't manage the purse strings for most of the lawyers. Now, those of you that have hired private practice lawyers, you do. But if you threaten your private practice lawyer with, I'm going to fire you if you don't get this done, that's one of the last times you're going to work effectively with that lawyer, because they don't take well to that threat. It's like going to the politicians and saying, we're not going to support you, we're not going to raise money for you if you don't do what we want. That's not how you get stuff done in the legislature. It's not what's going to work for your lawyer either. But, hey, how can I help you help me? Any more information? Can you meet this deadline? Is this going to work for you? And to the extent you can modify things, great, but otherwise don't. There are 2 critical words in this sentence. And facts is actually the 3rd most critical word. Now, it's all about the facts. Let's separate fact from opinion. That's important. But the word all, it is common for your athletes to not quite tell you everything that's going on with them that might matter, right? You have that experience in your profession. We have it in mine too. So so getting all the facts. Think about what they all are. They're more detailed and they're more involved than it might seem on the surface. So think about really what needs to be understood by your lawyer. And then the pertinent is the other critical word here. Again, you have great examples in your profession. So you're working on an athlete's ankle. The fact that the athlete jammed his little finger on the previous play, you don't care. And it's not going to help you with the ankle. Okay, I picked a really obvious example because I'm not an athletic trainer, but bear with me here. The converse or corollary to giving all the pertinent facts is asking all the right questions. I implore you, ask the questions of your lawyers. It drove me nuts when my clients would not ask me questions. They just take my answer over the phone or in a meeting or in a memo or a letter, and they just run with it. Drove me nuts. There's no way on God's green earth that I gave a full and complete answer every single time. I know that. I did my best, and I tried to. But I don't know that my client understood me unless my client's asking questions. Now, the answers might be, yeah, I said that, and I hopefully am not so arrogant to say, yeah, I said that in the 5th sentence of the 18th paragraph. But getting that dialogue going is the only way you're going to know. And I included the word right questions because it's important that you really try to drill down into it. I talked earlier about not using questions to challenge your lawyer, but instead use the questions to understand. Questions that start with, I'm sorry, I don't quite understand, or can you explain for me something along those lines? And you don't have to remember the exact words, but that tone is what we're after here so that you can get those answers. But try to understand what it is that you don't know. One of the challenges in dealing with legal issues that I have found with clients is they get distracted over here with stuff that kind of correlates with what they do know. But the real point here is over here. And when it's over here, that's when we can have a really good conversation. Now, as a lawyer, I might try to bring that conversation back over, and that is taught in law school, by the way, because it's an important skill for trial work. But it's also important for you to think about what it is you really want to know, or need to know, or don't quite understand. And as adults, we're pretty quick to respond to that. I do a lot of work with youth, and I find that children are actually often better at getting to what they don't know because they know they don't know anything. We lawyers try to fake it. Yeah, I understand. Oh, yeah, okay. Now, sorry, that answer you got from the lawyer to that question you just asked, you still don't get it. Okay. That's not an insult. It's the challenge we have as adults. We like to look good. We don't want to look bad in front of our peer board members, certainly not the board administrator, and the lawyer. Ask the questions. Get to the details. Feel free to sound stupid because the odds are your stupid question is the right one. Odds are. Now, the challenge here putting this in front of a board member is a little troublesome because you don't want to know the outcome of the actual hearing or case or whatever before you start. That's illegal. It's bad stuff. Justice Chase almost got thrown off the Supreme Court because of it. Things like that. Bad news. But to the extent that you do know where you want to go, whether it's a regulatory process or policy making or an attorney general's opinion, the variety of things you do, disciplinary matters, if you have an idea of where the direction is, then you're asking the lawyer to help you get someplace. And that's a better structure for getting high quality work from a lawyer than simply saying, how do I? Or what is this? Now the lawyer's working in a vacuum or working in her own preconceived notion of what that outcome should be, which may or may not match yours. Goes back to the communication issue, but it's also how do you manage people? If they know the direction the train is moving, then we can all move in that direction. Now the lawyer might have to say, nope, sorry, that train can't go there, in which case you're going to need to understand why, and then ask the lawyer, how do we get it to go someplace really close? Or is there another way to get to the same place? And this is another challenge from the lawyers that serve boards, at the risk of stereotyping, is many of them are not as creative as they could be. So if you as board members and board administrators can help that lawyer be more creative for your benefit, it will serve your needs better. But they can only do it if you can describe what that outcome is. And this kind of gets to it. This lawyer was very creative. I love this answer. I couldn't get them where they needed to go because of restrictions within the law, the rules, whatever it is. I couldn't get them there, but I figured out another way that actually took me out of the equation. Well, that may or may not be a good thing, but it got my client, the board, where they needed to go. That's what you're after. That's what you want to try to draw out of your lawyer. So how do you do that? Establish a relationship. Board administrators, when was the last time you and your attorney went to lunch? It's a great strategy. They may represent 18 boards, or 25, or 3. But if you're going to lunch once a year, twice a year, it doesn't have to be every other week. You've got a relationship going that transcends the business and incorporates it. Because what are you going to talk about at lunch? What do you have in common? You have in common not only that you both love dogs, but you have in common the law. You have in common what's going on with athletic training board. You have in common what's going on with athletic trainers, even though it sounds like that's less common, but your lawyer wants to know. So that part of that conversation over lunch just naturally is going to include that. Just an idea. Invite them to a retreat. If you have a board retreat, invite your lawyer. If you don't have a board retreat, it's not really part of this conversation, but have a board retreat anyway. It's a good idea. So, relationship, communication, education, and think strategically. Those are my themes for the day, and I guess we have time for a couple of questions. So maybe I bored you the last time. You want to go back and guess 90% again. But anything I can share with you on trying to get more out of your lawyer?
Hi. So we had trouble for a number of years with the Attorney General not approving new board members, so our board was sort of non-existent for a short period of time.
Fun.
Oh, yeah, it was frustrating. And the lobbyist that's hired by the state association actually managed to get in there along with some political changes and wiggle things loose. Is that an okay thing to do, or is that a conflict of interest? How is that viewed?
Oh, okay. Well, the relationship between the profession and the board is always an interesting thing. I think you may have noticed in the first slide, I'm the public member on the Federation of State Boards of Physical Therapy board. And that question actually comes to us often on that board as well. So the interests of the profession and the interests of the board are not identical. They can overlap. There can be occasions when the profession and the regulatory board are pulling in absolutely the same direction, and should be, and all is great and wonderful when that happens. And so then being able to use the profession's talent or resources is a great thing, as long as you don't get so closely in bed with each other that the board can't do what it needs to do, because the profession is about protecting the profession. I was a lawyer, so our job was, let's protect the lawyer. That's what the state bar does. That's what the American Bar Association does. But the board is challenged with public protection. So it's not the same thing. The lobbyist hired by the profession is going to be responsive to the profession, not to the board. Maybe on a given matter it works, but be really, really careful.
How do you resolve conflict between your board administrator and your board attorney?
That never happens. So conflicts are possible in all things human, right? And that's why I talk about the relationship. We're in the relationship business. Lawyers are in the relationship business. The board administrators are in the relationship business. It's how we get everything done. How do you resolve it? Depends exactly on what's going on. So typical lawyer answer. Amigo told you that yesterday. It depends. That's a lawyer's response. But let's work through a few. So if you can get the board administrator and the attorney in the same room, it's a good place for the board chair to take charge. I mean, it is the chair, right? That's the person that is in charge. You don't always see that in action because the administrator runs the meeting or the attorney runs his portion of the meeting. But this is an occasion when that board chair maybe needs to take a special trip down to the Capitol, get those two people into a room, and let's resolve this. Or maybe talks to them separately to work out. The board chair doesn't always have to work through the administrator to get to the attorney. I have not seen in any state any law that says it has to be that way, even though it commonly happens because that's where the administrator is. It's what the administrator does. But it winds up being an interpersonal solution. So trying to work on it that way. Trying not to do that in the public session that's subject to the Open Meetings Act is a good idea. To the extent that conflict can be avoided in that setting, it's a really good thing for everybody. But sometimes individuals need to be reminded of that, be they the lawyer, the board executive, or even a board member. Now's not the time. Let's take that out. We'll talk about that separately or later. So interpersonal skills management is the short answer to the question. And yes, it does happen. Okay, well, I thank you for your time. I hope that was helpful to you.